This lecture focuses on employment discrimination law, specifically the Civil Rights Act of 1964 and Title VII, which bans employment discrimination. In Title VII of the Civil Rights Act of 1964, it prohibits employment discrimination. It also identifies and classifies what is called a protected class of people who have historically been discriminated against in the workforce. These classes include race, color, national origin, meaning you were born outside of the United States but currently live in the US, sex, and religion. In terms of the organizations that Title VII applies to, it includes businesses with 15 or more employees who are employed for 20 consecutive weeks in a year, and companies who engage in interstate commerce. So these days it's really difficult to not engage in interstate commerce due to the internet. Under Title VII, there are two types of employment discrimination claims. The first is disparate treatment. This is when an employee believes that they were intentionally discriminated against by the employer. In order to bring this lawsuit forward and win, the employee needs to show that there is enough evidence of discrimination for the lawsuit to proceed, which is a prima facie complaint, and two, that there is no quote-unquote business reason for whatever the employer has done, like not giving them a raise, not promoting them, or so on, just discrimination. The employer, on the other hand, needs to show that they have a legitimate business reason for this type of treatment that the employee feels is actual discrimination. A second type of employment discrimination claims is disparate impact. This is an unintentional form of discrimination that has a discriminatory impact. So whatever the employer is doing results in employees not reflecting the population in that area. For example, an employer can be administering a specific type of test that rules out part of the population and may not actually be necessary to perform the job, is an example of disparate impact. The next few slides review the defenses an employer can use when presented with the Title VII employment discrimination claim. The first is bona fide occupational qualification. This states that an organization can discriminate only if it's necessary for the job. It's based on specific qualifications. So for example, locker rooms are generally split male only, female only. So an organization could create a job description that specifies they're looking to hire a locker room attendant and say that you have to be female to work in the locker room or you have to be male to work in a locker room, which eliminates some groups of people, but it's based on specific qualifications, and they can argue that it's necessary for the job that they have a specific gender in each locker room. Keep in mind that race and color are never allowed as a bona fide occupational qualification. Another defense to a Title VII employment discrimination claim is that the company uses a merit-based system. This means that people are hired and promoted based on how productive they are in their job. So a thing like sales, the company can argue that this person was promoted because they had the highest sales over the last quarter compared to their colleagues who maybe didn't do as well and didn't hit their numbers. Another defense to a Title VII employment discrimination claim is the seniority system. The company would argue that promotion or raises are based on the amount of time an employee has worked for the company. So for example, at the 10-year mark, every employee gets a $5,000 raise regardless of performance, and it's not discriminatory because they've just worked at the company longer than another person has. Title VII of the Civil Rights Act also prohibits sex discrimination in employment. Sexual harassment is considered a form of gender discrimination. So this includes discrimination in hiring, promotion, salary, and pay raises. Title VII of the Civil Rights Act also prohibits retaliation against an employee who files a sexual harassment complaint. So employers are not allowed to fire, demote, withhold pay from someone who files a sexual harassment complaint in the organization. The Civil Rights Act Title VII also outlines some elements of sexual harassment. This can be unwelcome sexual advances, verbal or physical conduct, which are not desired by the victim, and the conduct creates a hostile work environment in which the victim cannot do their job. There are two specific types of sexual harassment. The first is what was just described as hostile work environment, which is severe, pervasive, or objectively offensive behavior that makes it difficult for an employee to get their work done. The next is quid pro quo. This is the pressure to provide a sexual favor in return for something like a pay raise, a promotion, more vacation days, better schedule, or access to a better client list. To summarize, the Civil Rights Act of 1964, Title VII, bans discrimination in employment based on what they classified as protected classes. These include race, color, national origin, sex, and religion. Title VII also bans sexual harassment in employment and bans retaliation against the employee who files a complaint.